Ask the Court program is produced by the Public Information section of the International Criminal Court. In this program, people from 8 situation countries are given the floor to ask questions to the court. In this edition of the program, questions from people in Kenya are answered by Maria Kamara, the court's outreach coordinator in Kenya, Fadi Abdallah, the court's spokesperson, Phakiso Mochochoko, head of the jurisdiction, Complementarity and Cooperation Division of the Office of the Prosecutor, and Mikel Delagrange, legal officer in the court's Victim Participation and Reparation section. Will the International Criminal Court continue proceedings against Mr. Uhuru Kenyatta and Mr. William Ruto now after the elections results have been announced?
Yes, the proceedings will continue. No one is exempt from prosecution because of his or her official capacity. Article 27 of the Rome Statute, to which Kenya had made a sovereign decision to join, holds that neither the immunity of a head of state nor the official position of a person suspected to bear the greatest responsibility for crimes under the ICC would bar the court from exercising its jurisdiction. Therefore, for the purposes of trial proceedings before the court, the Kenyan election results do not alter in any way the jurisdiction of the ICC. While the court is aware of the political developments in Kenya, these have no bearing or influence on the ICC as an independent judicial institution. At present, Mr. Kenyatta's trial is scheduled to commence on 9th July and Mr. Ruto and Mr. Sang's on 28th May this year.
Why have the judges postponed the start of the trials in the 2 Kenyan cases?
On the 7th of March 2013, the Trial Chamber 5 of the International Criminal Court decided to postpone the start of the trial against Mr. Kenyatta and provisionally set the date for the 9th of July 2013. The judges postponed the start of this trial upon the defense request, considering that a number of important legal issues raised by the defense would need to be resolved before the start of the trial, including, among other issues, the request for the case to be sent back to the pretrial chamber. And the next day, on the 8th of March 2013, Trial Chamber 5 decided to postpone the start of the trial against Mr. Ruto and Mr. Sang to the 28th of May 2013. The judges have postponed the start of this trial also based on a defense request because the defense asked for more time to prepare since key information was disclosed to them only in January 2013. So the judges granted the defense's request. The date of the trial opening is now set for the 28th of May 2013.
Will Mr. Kenyatta and Mr. Ruto be required to attend trials in person, or will they be attending trials remotely via video link?
At the ICC, trials cannot be conducted in the absence of the accused person. The accused must be present at their trial. In a filing on 28th February this year, Mr. Kenyatta's defense requested the judges to have him participate in his trial via video link. The judges have yet to decide on this issue and to decide whether this participation will satisfy the legal requirement of the accused presence at his trial. At this stage, we cannot speculate on their decision.
Where will the trials be held? Under the ICC system, is it possible to hold trials outside the seat of the court in The Hague?
Unless the judges decide otherwise, trials will take place at the seat of the court in The Hague, in the Netherlands. According to the Rome Statute, the conduct of trials in a situation-related country or another location may also be ordered by the judges. The defense lawyers for the accused persons have filed submissions requesting the judges to hold the trials in Kenya or in Arusha in Tanzania. A decision by the judges is expected on this issue. It is, however, important to note that, irrespective of the territory where the trials will take place, the cases remain under the ICC's jurisdiction. The trials will be conducted by ICC judges and guided by ICC legal principles.
What is the impact of the withdrawal of charges against Mr. Mudhaura on the case against Mr. Kenyatta?
The answer to that is that in a 13 March 2013 filing to the judges, the Office of the Prosecutor highlighted the fact that the prosecution has consistently alleged that Mr. Mudhaura and Mr. Kenyatta played different roles in the post-election violence. As such, the evidence presented against one was different from evidence presented against the other. And the prosecution position is that the withdrawal of charges against Mr. Mudhaura does not in any way legally or factually alter the prosecution case against Mr. Kenyatta.
Does the withdrawal of witness number 4's evidence have an impact on Mr. Kenyatta's case?
In response to witness 4's recanting his testimony, Mr. Kenyatta's defense team has requested the trial chamber to send this case back to the pre-trial chamber for reconsideration of the decision to confirm charges against Mr. Kenyatta. The Office of the Prosecutor is opposing this request, considering that in the prosecution's view, there's no legal basis for the request, that without evidence from witness 4, the pretrial chamber would have confirmed the charges at the pretrial stage by relying on the other evidence that the prosecutor presented. Ultimately, of course, it will be for the trial chamber to decide on the request from Mr. Kenyatta's defense in due course.
The Office of the Prosecutor indicates that new evidence will be presented against Mr. Kenyatta. Does this mean that the case will be sent back to pre-trial chamber?
The answer to that is no. The Office of the Prosecutor continues its investigations in Kenya, even after the charges have been confirmed. If new evidence is collected, which is related to the charges already confirmed at the pre-trial stage, the prosecutor can present that evidence before the trial chamber. Now, on 7 March 2013, Mr. Kenyatta's defense applied to judges of Trial Chamber 5 to refer the case back to pre-trial chamber for reconsideration of the charges that were already confirmed. They said this because one prosecution witness, normally referred to as witness 4, recanted his testimony. ICC Trial Chamber 5 will decide in due course on this request.
Will the ICC compensate or refund Mr. Mudhaura's legal fees and other expenditure he may have incurred since the charges against him have now been withdrawn?
According to the Rome Statute, a person who has been victim of unlawful arrest and detention or a serious miscarriage of justice that led to a conviction after a trial may have the right to compensation. Mr. Mudhaura has never been arrested, nor has he been in the ICC's custody. And he has also not been convicted, as the prosecutor's decision to withdraw charges against him was made even before the commencement of his trial. Thus, this rule does not apply to him.
Will the victims of the 2007-2008 post-election violence get justice from the ICC, given the prosecutor's withdrawal of the charges against Mr. Mudhaura?
The cases against Mr. William Ruto, Mr. Joshua Sang, and against Mr. Uhuru Kenyatta are scheduled to start on 28 May and 9 July 2013, respectively, for the same charges as already confirmed by the pretrial chamber. The withdrawal of the charges against Mr. Mudhaura will not affect victims' participation at trial. Victims who wish to participate will be able to do so in both the Ruto and Sang cases, as well as the Kenyatta case.
How can victims participate at trials based on the judge's decision on victims' participation?
First off, participation is an opportunity for victims to tell the ICC judges about the harm that they suffered as a result of the crimes being tried at the court, as well as how they continue to suffer as a result of those crimes. In order to avoid having victims travel long distances to The Hague, participation is done through a common legal representative, appointed to represent their views and concerns in the courtroom in The Hague. Participation is free of charge. Now, the judges from Trial Chamber 5 have outlined a system for victims to participate at trial that is different from other situations before the court, and different from the system that was utilized ahead of the confirmation of charges hearing in the two Kenya cases. The individual application form will no longer be necessary for victims seeking to participate at trial. In this new system, it will be the common legal representative who, with the help of the Victims' Participation and Reparation section, will be charged with facilitating victim participation by locating the relevant victims, and by relevant I mean those falling within the scope of one of the two cases, verifying their status, and taking the necessary information to be submitted to the registry. Once this has been done, the common legal representative will then be charged with relaying the views and concerns of the victims to the ICC judges at the appropriate moments during the trials. Those interested in participating can find more information at the website and may contact the VPRS directly.
The Office of the Prosecutor mentioned threats on witnesses in the Mudhaura case. How can the ICC ensure these threats are not repeated in the Kenyatta case?
The prosecutor has in the past publicly stated that the scale of witness interference that the office has encountered in Kenya cases has been unprecedented. The court has developed a program to protect witnesses with appropriate and proportionate measures when needed, and will address the situation in Kenya in an adequate manner. Protective measures may, for example, include anonymity of witnesses, the use of pseudonyms, the redaction of documents, or the prohibition of disclosure thereof, and the use of audiovisual techniques which can disguise the identity of witnesses appearing before the court. The court also ensures that witnesses are provided with adequate protective and security measures through long and short-term protection programs. Under exceptional circumstances, the court may decide to relocate on a temporary or permanent basis a witness.
What are the possible legal action if it is proven that ICC witnesses have been bribed or have been found to lie?
Under the Rome Statute, acts such as the bribery of witnesses or giving false testimony are deemed as an obstruction to the administration of justice. In such a situation, the court may sanction the person who has lied or bribed the witness, imposing a fine and/or a term of imprisonment not exceeding 5 years.